Good morning and welcome to the National Press Theatre. My name is Rachel Haynes and I'll be moderating today's press conference. We will start with remarks from the Privacy Commissioner of Canada, and then following that we'll go to any questions that we have in the room, and if time allows we can go to questions on Zoom. I would just ask if anybody's using a headset or the earpiece today, when you're not using it, please put it on the sticker that you see at your desk just to protect the health and safety of our interpreters. And with that, I will hand it over to you.
Thank you so much. Thank you for being here. Merci d'être ici. Artificial intelligence and other emerging technologies are fueled by the mass collection and use of data, including personal information. While technological innovation can bring important economic, societal, and public interest benefits, the value of innovation can be jeopardized when it is not deployed with appropriate safeguards. A few months ago, reports emerged that Grok's image generation tool was being used to generate millions of sexualized deepfakes without consent. Given the serious risks for Canadians' fundamental right to privacy and the potential harms, I initiated an investigation on this issue into X Corp and XAI. The investigation has found that X Corp and XAI violated Canada's federal privacy by launching the Grok AI-powered image generation tool without implementing appropriate safeguards from the outset. This lack of protection allowed users to create and share sexualized deepfakes, largely targeting women and children. According to researchers, Grok was at one point generating well over 6,000 sexualized images per hour. We know that sexualized deepfakes can have devastating impacts on victims. Canadians, and especially our children, must be able to safely navigate online spaces. Just yesterday, the government tabled legislation that would create new requirements for social media services and AI chatbot services. I welcome these efforts to implement measures to make the online world a safer space. This is also why I launched the Grok investigation. Depuis que cette affaire a été portée à l'attention du public et durant mon enquête, X Corp et XAI ont mis en place des mesures de protection visant à réduire le risque d'utilisation à mauvais escient de l'outil pour produire des hypertrucages à caractère sexuel, ainsi que des mécanismes permettant d'examiner et de supprimer le contenu non conforme. En réponse aux recommandations formulées par mon commissariat, les entreprises se sont engagées à mettre en œuvre un certain nombre de mesures supplémentaires. Ces mesures consistent notamment à renforcer leur processus formel visant à prévoir et à atténuer les enjeux relatifs à la protection de la vie privée qui sont associés aux outils de génération d'images et à d'autres nouveaux produits, ainsi qu'à fournir régulièrement des rapports au commissariat afin d'expliquer et de démontrer l'efficacité de leurs mesures de protection. In particular, they committed to proactively and regularly monitoring for sexualized deepfakes before an incident is reported, not only in response to incidents, and to providing my office with documentation and regular audit reports until we are satisfied that the issues have been fully resolved. While these new remedial measures and commitments are encouraging and an important outcome, my office will continue to monitor the implementation of the company's commitments to ensure that the serious issues that we found are fully addressed. Importantly, these measures should have been put in place at the outset, not after the fact, not after the harms. Bingo. This case should serve as a powerful reminder for all organizations, especially those developing and deploying emerging technologies like AI, about the importance of prioritizing privacy at the outset of any initiative. Privacy must be embedded into the conception, design, operation, and management of products and services, because appropriate safeguards are the cornerstone of responsible innovation. This investigation demonstrates that Canada needs modernized federal privacy laws that will better support the development of trustworthy, privacy-protective technologies and help Canadians and Canadian organizations to thrive in today's modern, data-driven world. J'accueille favorablement l'engagement pris par le Premier ministre du Canada de moderniser la loi fédérale sur la protection des renseignements personnels dans le secteur privé afin de consacrer un droit fondamental à la vie privée, de protéger les renseignements des enfants contre l'exploitation et les préjudices et de renforcer le contrôle des individus sur leurs renseignements personnels. Le premier pilier de la nouvelle stratégie nationale en matière d'intelligence artificielle annoncée la semaine dernière par le gouvernement est de protéger les Canadiens et préserver notre système démocratique. La stratégie fait ressortir l'importance de mettre au point une IA sécurité, comprend un engagement visant à moderniser les lois sur la protection des renseignements personnels et la sécurité en ligne afin de soutenir cet objectif. I believe that modernized privacy laws would help build trust in AI and better support Canadians and Canadian organizations to thrive in today's modern data-driven world. A new law should establish a legal obligation for organizations to implement privacy by design and to conduct privacy impact assessments for high-risk activities. I've also called for stronger enforcement powers, including administrative and monetary penalties, as well as the power to issue binding orders to ensure that organizations respect Canadians' fundamental right to privacy and do so at the outset. L'innovation technologique peut procurer d'importants avantages pour l'économie, la société et l'intérêt public du Canada. Pour tirer pleinement parti de ces bénéfices, l'innovation doit reposer sur des bases solides et sécuritaires qui tiennent compte avant toute chose de l'intérêt supérieur des Canadiennes et des Canadiens. Merci et il me fera plaisir de répondre à vos questions.
All right, thank you so much. We'll move to our question and answer period. We'll start in the room. If you are on Zoom and have any questions, please use the raise hand function now. And we'll start with Ryan Tumulty from the Toronto Star.
Commissioner, you mentioned in your statement that you are not empowered currently to administer monetary penalties for this. Do you think that prevents or do you think that it acts as a disincentive to companies to do a privacy assessment in advance, like you seem to think X should have done in this case?
Absolutely. I think the lack of the possibility of fines, possibility of orders, makes it more difficult to convince the decision makers to invest in privacy at the outset. We know that investing in privacy at the outset is a good investment. It makes products better and it protects individuals. But the fact that at the end of the day, even in a case like this one, there is no ability to impose a financial consequence. There's no ability to impose an order. That creates a lack of incentive, and in some cases, maybe a disincentive to comply with the fundamental right to privacy. So that's a major gap. That's something I've been calling out since my appointment as Privacy Commissioner 4 years ago.
And images similar to the ones that you raised concerns about still seem to pop up on Grok and on Twitter. It doesn't seem like this problem has entirely gone away. Are you concerned that the company isn't taking this seriously because you don't have the opportunity to find them?
Well, a clear outcome. One, I don't have the ability to find them, and two, I don't have the ability to issue an order. So one of the recommendations that we made was that they suspend the tool until they can put in place all of the appropriate safeguards. So press pause, fix the issue given the harms, and that gives an incentive to fix the issues quickly so that you can reopen the tool. And they've not accepted to do this, and I can't force them to do it. And so they've accepted my other recommendations to put in place the monitoring systems, the proactive, and a lot of good commitments. But we found in the report that's not yet resolved because a lot of those things are future looking. It will help, it will reduce, it has reduced it by 50%, but that still means there's still many, too many. One is too many. And so absolutely, that's an example where we would need strong enforcement power. I note the company's agreement to a number of the recommendations and a number of steps that are taking. This is positive, but it's not done. We're going to monitor so that it is fully done. But again, even when it is fully done, those harms have already occurred. They should never have occurred.
Maria Collins from the Wire Report.
Hi, thanks for taking our questions. So just to clarify on that, based on the measures that X has agreed to put in place, they are still non-compliant with our privacy law?
They're still non-compliant. They have made some commitments to bring themselves in compliance, but in this case, I was not satisfied that this issue is resolved. So I will be monitoring. Part of their commitments, they're going to be giving us quarterly, annual documentation, reports, audit reports. They're going to be bringing us information about the steps that they've put in place, the results, the statistics, the takedowns, all of those things. And so we're going to monitor that very carefully. And if we're not satisfied with the measures that have taken, then we'll consider our alternatives. But again, my alternatives under the current law would be action before the court, which is lengthy and consuming. And so this is why we need enforcement power that would be stronger and faster for Canadians.
Okay, so even you called for updated privacy framework, even if X or any other chatbot image generation tool were technically in line in compliance with our privacy framework, since it's not updated to scope in sort of our technological environment. Do you think that these services are safe? Do you think that they're privacy protected even if they're technically in compliance?
Well, right now what I see is we need to have more upfront compliance. We need to have these impact assessments and these mitigations measures right at the start. And unfortunately, this is not happening in all cases. It's not happened in this case. And so we're in a situation where we have to react after the fact. And this is where having a modernized regime with proactive obligations and stronger enforcement power would lead to better outcomes for Canadians.
Thanks. Laura Osmond from The Logic.
Hi, Commissioner. Thanks for taking our questions. As I'm sure you know, the federal government tabled legislation last night related to online harms. That includes a new commission focused on online safety. Do you see a role for that commission that does have the power to impose orders and fines with regard to data security? And how will your office kind of interface with that new regulator?
Absolutely. Well, certainly there is a role for this new proposed regulator in the context of online harms. There's going to be some powers to assess the steps taken by organizations, and Minister Miller talked about this yesterday, not reacting after a complaint, but having an obligation to take these proactive steps. And many of these principles are in line with the priorities and recommendations that I've made in the past: protecting children, having the clear, accessible ways for users to flag harmful content, intimate content communicated without consent. I'm pleased to see this included. That is an ongoing issue that we have been having with Pornhub and MindGeek in terms of their takedown mechanism. So there's going to be a positive role to play, absolutely, again, should Parliament adopt this legislation. And there are provisions where my office would be exchanging and consulting with that regulator, and I would expect this to be the case, as we do with the CRTC, with the Competition Bureau, so that we coordinate our efforts to maximize impacts.
I'm wondering if you have any concerns about the social media ban and the implications for privacy, given that people are going to have to prove their age, and that's going to require the collection of personal information.
Well, I've already stated in the context of reviews of Bill S-209, Senator Miville Deschênes' case, that it's not a zero-sum game between protecting children online and protecting the privacy rights of Canadians, and that's true in the context of age assurance. So we can do this, and we must do this in a privacy protective way. I've recently issued guidance on this in the last few weeks, talking about some of the key principles of data minimization, using it only for the purpose of that verification, not keeping it for any longer. And again, bill was tabled yesterday. We're reviewing it, but I note that there are some requirements in there in terms of the types of age verification that touch on some of those principles. There's as I understand, possibility that some would be added by way of regulation. So we're going to review all of that. I look forward to providing advice at committee at the appropriate time, but certainly we've stated a lot of our expectations on age assurance on those things. Again, protect it, make sure that there are no privacy breaches, don't take more than you need, don't keep it for longer, don't use it for other things, don't track individuals, all of those elements, that has to be front and center. And this is a conversation that's going on around the world. I'm having discussions with my G7 counterparts on this, and we're going to continue to provide guidance. But again, I would point to the guidance that we've recently published in the last few weeks.
Not just collecting data on kids, mind you. That
Thanks. We'll go to Nick Murray from the Canadian Press.
YouTube is trying to collect my passport.
Hi, good morning, Commissioner. I'm wondering if you can go back to your interaction with the company. I know you mentioned earlier that they did not accept the recommendation to pause Grok, but I'm wondering if you could elaborate a little bit more on like their willingness to do the things that they are doing, and whether or not the company showed a sign of taking this issue seriously.
They did. There was good collaboration with the company in this case. They've identified a number of steps that they took, starting in December, January, in terms of bringing more robust verification, reducing some of the functionalities for paid users, having more verification. So that's been part of the discussions that we've been having in the context of this case. That was part of our recommendation to say, well, pause it, put those measures in place. They didn't agree with us in terms of the pausing, but they did commit to the steps that we want them to take in terms of fixing the issue for the future. But I want the issue to be fixed right now. There will be stronger monitoring. There are going to be more tools to enhance user interface. There'll be more prominent warnings. And one of the great outcomes is that my office will be getting periodic review, some quarterly, some annually, until we are satisfied that it has been fully addressed. And that's going to include statistics. That's going to include the results. Because it's one thing to say, one of the things we said in the report is the statement being made that this will reduce it, this will prevent it. That's good, but has this been demonstrated? And has it been reduced, and by how much? Reducing it by half, to me, is not enough. It has to be reduced almost to zero, if not to zero. So there's good commitment in terms of exchange of information. So I've stated I'm encouraged by those commitments. I'm encouraged by those remedial actions, but we will monitor it because the issues are serious, and it should never have happened in the first place.
And just really quick, I'm wondering if you could reflect on Bill C-16, which in parts criminalizes sexual deepfakes, and whether you think that bill does enough to address situations like this.
It's part of the solution. It's an important tool. Criminal law is an important tool, and that was one of the issues in this case. One of the arguments that was being made was that the companies were saying, well, it's the users who are doing this. They're asking the AI to do these deep fakes, and we don't agree with that. We don't condone that, but that's really the issue. It's a user violation. So other tools like that, the criminal law can deal with that. That's true. Criminal law can and should deal with some of those issues. But we found that there is also an overarching obligation on the company that is making the tool available to make it such that it is privacy protective, to make it such that it protects Canadians, that it mitigates, that it takes down. And so the similar themes that we had in the investigation of Pornhub, where people are posting revenge porn on porn sites, the people doing that absolutely should be dealt with and prosecuted and so on. But the company has an obligation as well, because if you rely only on criminal law, it's going to be reactive, and you're going to have significant harm that we need to prevent.
Thank you. Stephanie Taylor from the National Post.
Hi there. Thanks, Commissioner, for taking our questions. I just want to go back to when you say the company did not, hasn't accepted your recommendation to simply suspend the feature. What was the explanation they gave as to why the answer was no to that one?
Well, they felt that they were doing enough to prevent it. They felt that the measures that they had put in place were sufficient, and we disagree on that point. So we feel, I continue to feel, that it should be paused until they can put in place the additional measures and satisfy us that they've been put in place. They took the view that that they're not prepared to do this at this stage, and so the other recommendations they've accepted. But on this, that was the disagreement. We found that the risk mitigation measures were not enough. and that they had to do more.
What does that tell you about how seriously they take the issue?
Well, what it tells me is that without the ability to issue orders, that's a gap in terms of how we can resolve the issue. And it's an outcome that can happen if an organization refuses, and this has happened in the context of Pornhub, the organization refusing to put our recommendations. In that case, all of our recommendations were not met by MindGeek. So that creates delays for Canadians. And those harms and those delays could be avoided by having stronger enforcement powers.
Thank you. Waleed Tamtam from the Western Standard.
Awesome. So I want to ask you, given your observation of the private sector, what's a company that is employing an ideal methodology for age verification that is balancing both privacy and effectiveness? I know Discord has a number of methods that they're using after receiving much pressure in the US and Australia. AI software to verify people's age vis-a-vis facial features, ID uploads, and other kinds of things that are accessed in a database that is relatively secure. Just what do you think is an ideal methodology, given the fact that there are a wide range of methods?
Right. Yeah, we have not endorsed a specific technology or a specific methodology. We're open to different approaches, but we have highlighted some of the key principles. Those are highlighted in our guidance on age assurance, and we talk about proportionality. We talk about data minimization. We talk about retention. We talk about avoiding secondary uses, avoiding tracking. So all of those things are key, and those things have to be set out in the legislation and in the bill that was tabled yesterday. Some of those principles are there. We're going to review to make sure if there's some gaps. We'll make some recommendations to the appropriate parliamentary committee, as we have done in the context of Bill S-209. And the guidance is there again for all organizations to look into that. And that is a conversation that's taking place globally, and we're going to continue to take part in it.
Doug Ford
Follow up
to the Washington
on the
other day
section
without
of multimedia
talking to
usage
people about
of
it
these
and
AI
signing agreements.
sexualized deepfake material.
Ontario
Has
tighter to the
your office
US
done any
while
look into in
Canada's
terms of
trying
the
to
video
pull
game
away.
industry and the fact that some games and some
Ontario's
software
gonna
programs
suffer.
on the
And
rather open video game market are using material that has been generated by Grok and other AI tools, and then are inputting into the platform or recreating a certain
do is you don't
AI mechanism
drop
within
down,
their
you just
game that
block it
generates
and
or
send it
creates a
altogether.
certain
No reason
album
for it.
of sexually explicit
Filter
material that may not be seen to
Twitter.
the wider public, given its industrial closet.
Well, I think the key point in here is that any organization that becomes aware of sexualized deepfakes on their platforms, whether it's games, whether it's anyone, should be flagging that, should be taking that down, and should be part of the privacy protective approach should be to provide access and ways for users to flag those things. So we're going to be working on this with Grok in terms of the bill tabled yesterday. My understanding is that's going to be part of the principle in terms of duty to act responsibly, duty to act to protect children, duty to be transparent, duty to make certain content inaccessible. But certainly in terms of the gaming industry, we are monitoring the situation. We've commissioned some research on that. We haven't addressed it specifically in the context of this investigation, but again, the principles that are coming out of this investigation, any organization that in any way are involved in these types of practices or in contact with this type of content should take note of the obligations that have been seen in this case. The privacy law requires consent for this, express consent, and in many cases it's not going to be possible to obtain it. And privacy law finds that this is absolutely an inappropriate use of personal information, and that is absolutely not warranted by any of the benefits that would flow from the use of those sexualized deepfakes, if any.
Thank you so much. We'll now move to Zoom. If you do have a question on Zoom, please use the raise hand function and unmute yourself. We'll start with Boris Prou from Le Devoir.
Bonjour, Monsieur le Commissaire. Est-ce que j'ai bien compris que vous avez parlé ou en tout cas documenté des victimes canadiennes, enfants, dont les données personnelles ont été utilisées pour générer du contenu sexuel là, par intelligence artificielle et que c'est encore possible en ce moment où on se parle sur Grok de faire ça?
Bien, nous, ce qu'on a conclu globalement, c'est qu'effectivement, il y avait eu du contenu canadien qui avait été enlevé par Grok dans le rapport. On fait de 126 postes. Donc, il y en a eu. Et au niveau de est-ce que ça continue encore? Nous, on n'est pas satisfait au moment où on se parle que les mesures sont suffisantes pour mettre fin à tout ça. On est encouragé par les engagements qui sont pris, mais on va attendre de voir la documentation dans les rapports qu'on va recevoir et on va suivre ça pour s'assurer que non seulement le contenu existant est complètement enlevé, mais qu'il y a des mécanismes suffisamment rigoureux pour que ce soit identifié rapidement et enlevé rapidement. Alors, les engagements sont pris à cet effet et comme je vous dis, et je le note parce que ce n'est pas toujours le cas, il y a une reconnaissance et un engagement à nous fournir de façon proactive des rapports. Alors, ça va nous permettre de continuer une fonction de vérification, d'audit par rapport à ça. Et donc, on va le faire très rigoureusement. Et si on n'est pas satisfait que ça a été suffisamment réglé, bien, on va prendre les mesures nécessaires.
En suivi, est-ce que vous pensez qu'il y a des questions, des trouvailles là, de votre enquête qui dépassent votre mandat, qui pourraient aller dans la sphère pénale? Est-ce qu'il pourrait carrément, selon votre avis personnel, là, y avoir des responsables de Grok visés par une enquête judiciaire qui méritent de la prison peut-être?
Nous, on n'a pas fait de constatation par rapport à ça au niveau. On a enquêté Grok et l'organisation en vertu de la loi sur la protection des renseignements personnels. Donc, on a conclu que là-dessus, il y avait eu manquement et que ce n'est pas encore réglé. L'enquête a certainement mis la lumière sur le fait que des individus qui postaient des hypertrucages à caractère sexuel pouvaient être en violation de lois civiles ou criminelles, mais ça dépasse l'étendue de mon mandat. On a par ailleurs aussi noté que même si ce n'était pas l'accent de notre enquête, parce qu'on voulait faire avancer ça rapidement au niveau des hypertrucages à caractère sexuel, mais il y a d'autres types d'hypertrucages qui sont problématiques également au niveau de violence ou au niveau de situations abusives. Et dans le rapport, on note que ces situations-là sont probablement en violation de la loi également. Mais ce n'était pas l'objet de notre enquête, mais on a émis un avertissement par rapport à ça dans le rapport.
Thanks. Next, we'll go to Mickey Jurek from Politico. Mickey, please unmute yourself.
Thank you so much. I guess, so my understanding is that X and XAI are still not complying with Canada's federal privacy law. I know you said that you're working on measures with them still, but what powers do you have to, I guess, eventually enforce the law?
Well, currently, if I am not satisfied and my recommendations are not met, I can initiate actions before the federal court. And so it goes through the court process, and it in a way starts over, where we bring a case before the court, and then we need to prove the violation of the law, and it's a lengthy process. And in cases where there's lots at stake, it can make its way all the way to the Supreme Court. So it's lengthy and it's expensive, and so this is why. Since my appointment as Privacy Commissioner, I've been advocating to have the ability to issue orders and to issue fines. Again, not in all cases, but in appropriate cases, so that, and we talked about it in some of the previous questions, it gives the right incentives to organizations. It brings Canada at the same level playing field as other countries. Most countries around the world, their privacy commissioner has the ability to issue orders and fines. So we stand out in that context. And it brings results faster for Canadians, because The orders can still be challenged in court by the company if the company feels that the decision has been made in the wrong way, and that's part of the legal process, and that's absolutely appropriate. But with the ability to issue the order, you could press pause, or you could have these protective measures effective right away. Instead of now, they would be effective months, if not years, after the fact. So it's a clear gap. I've been advocating for it now since the last 4 years. I hope that this is resolved soon.
Thank you. And then in your opening remarks, you shared a very startling statistic that Grok was at one point sharing 6,000 sexualized images per hour. Do you know how much that has been reduced by? And I guess, where'd you get that stat from?
So we've received that from a number of news reports. We talk about it in our report, and we give those sources. 6,000 sexualized deepfakes every hour, an estimated 1.8 million sexualized images since December 29, 2025. We have the Nonprofit Center for Countering Digital Hate, which estimated that between December 29, 2025 and January 8, 2026, Grok generated approximately 3 million sexualized deepfakes, including more than 23,000 images of children. So we have other statistics in our report at paragraph 26, and so we flagged that. Grok has highlighted that since they've reduced the numbers by 50%. So it's a big reduction, but that means there's still many that are there. And so that's why I'm not at this moment satisfied that it is resolved, and I will need more demonstration by the companies, and I look forward to receiving those and to assessing those.
Thank you. Our last question will go to Chloé Burquin from La Presse. Chloé, go ahead.
Oui, bonjour, est-ce que vous m'entendez bien?
Oui.
Oui. En fait, je voulais juste vous demander par rapport à la question de mon collègue du Devoir. Vous avez dit qu'il y avait eu 126 postes de personnes canadiennes que vous aviez recensés, si j'ai bien compris. Est-ce qu'il y avait beaucoup de femmes ou d'enfants parmi ces publications-là?
On a demandé un estimé de savoir au niveau si c'était des mineurs ou si c'était des adultes. Et puis, on n'était pas satisfait de toute l'information qu'on a obtenue par rapport à ça. On en a demandé par rapport à XAI notamment, puis ils n'étaient pas en mesure de nous donner essentiellement le détail de ça. Alors, on va continuer de suivre ça pour avoir plus de détails là-dessus et s'assurer que c'est enlevé et que ça n'est plus sur la plateforme. Mais on a vu dans les statistiques globales dont on a fait état que c'est un enjeu très sérieux et qui touche principalement les femmes et les enfants. Alors, c'est quelque chose qu'il faut traiter très sérieusement.
Également, je me demandais, j'ai bien compris que vous disiez que vous n'aviez peut-être pas assez de pouvoir actuellement pour justement lutter efficacement contre les entreprises qui laissent ces deepfakes-là circuler. Je me demandais, est-ce que les différents changements qui sont prévus dans les différentes lois actuellement, c'est suffisant selon vous pour lutter contre ce phénomène-là?
Bien, c'est une étape importante que je salue, le projet de loi qui a été déposé hier, le projet de loi C34, je crois, si je me souviens bien. Et donc, ça va amener des mesures importantes. Évidemment, il faut que si le projet de loi est adopté, et il y a ensuite la création de cette commission-là. Je pense qu'il y avait dans la présentation du ministre, on parlait d'une période de 18 mois pour créer ça. Donc, mais c'est sûr que les pouvoirs qui seront donnés à ce moment-là seront importants et que ça pourra amener l'incitatif pour traiter ces questions-là de façon proactive. Alors, c'est certainement un développement que je salue, mais il demeure que pour ma loi, en vertu de protection des renseignements personnels, il n'y a toujours pas cette habilité-là, cette capacité-là d'émettre des ordonnances et d'émettre des amendes. Alors, la lacune, elle est comblée en partie par ce projet de loi déposé hier, mais il faudra voir davantage. Et le premier ministre, dans sa stratégie, parlait de projets de loi au niveau du digital, mais aussi au niveau de la protection des renseignements personnels. Alors, j'espère voir ça sous peu et qu'il y aura à ce moment-là qu'on va recalibrer de façon appropriée le mécanisme de mise en œuvre de la loi.
Parfait. Merci beaucoup.
Thank you so much. We have no further questions. So
All right, so there you have it. We're going to call this one, and I hope you'll leave your comments and suggestions in the comment area. We'll see you later. Have a good afternoon. We'll be back. Bye-bye.